I think in the area of cloud computing, one of the impacts of moving data offshore that is highlighted in a lot of commentary is privacy and transporter data flows and the regulatory compliance issues that are associated with that. Now, the Australian government, much like other governments around the world, understands that its ability to protect its citizens' data really can end once the data leaves and heads to another country. And so that point of departure from one jurisdiction to another is really the last opportunity that a country has to exert some control and some protection over its citizens' data. That has led, in some cases, to cloud offerings being offered in a specific region, such as the EU. And there are public cloud offerings that will warrant that data won't leave the EU. It's also led to some offerings in the US, where there's commitments that data won't leave the US. Australia and its economic position, it's got a limited population compared to some of those large markets that I mentioned. It's unlikely that these significant public cloud offerings are going to be offered purely in Australia at any time in the near future. Many of the efficiencies are to do with load sharing across a diverse customer base and even load sharing across time zones, with our neighbouring time zones peaking at different times. So a lot of the efficiencies come from a regional solution, even access to cheap power and efficient labour, access to markets mean that there'll be a need to consider this compliance issue of transporter data flow with public cloud offerings. Now, under National Privacy Principle number 9, there are some restrictions on the transfer of personal information contained in data offshore. One of the topical issues which is coming up for cloud computing, which is our proposed new Privacy Act and Australian privacy principles. An exposure draft was issued in June of last year. The Senate Select Committee was meant to be meeting early in this term to consider that exposure draft, and it's been deferred. There have been a number of position papers put by various IT providers about proposed new Australian Privacy Principle 8, because it would have an impact on transported data flows. Now, the primary provision under APP 8 and the new Section 20 relating to transported data flows provides that before a company can disclose personal information to an overseas recipient, the disclosure must take reasonable steps to ensure that the overseas recipient will not breach the APPs. And even if those steps are taken, any breach by the overseas recipient of the Australian's privacy rights will be deemed to be a breach by the person handing the data into the cloud. Consent really is the extent of the issue to facilitate cloud commerce. The consent requirements are a bit more onerous than they are in the current legislation. It's still an exposure draft. But it's likely, if it went through in its current form, that all of those contracts where you click I agree to for your data to go offshore will have to be reworked to provide for an informed consent. The contracts considered emphasise that the burden of getting this consent is on the people putting the data into the cloud, the customers signing up for the cloud service. They're in a position to get the consent necessary to facilitate data being sent all around the world.